How's it going, Dan? Thanks
Great.
for sitting down and talking with me today.
Of course.
So I had a question. As a summer associate who has an interest in IP law but no background in the hard sciences, how hard is it to get into a firm when you don't have that patent experience, well, that hard science experience?
It doesn't make it impossible, but it depends on the right situation and a firm that might have a more expanded IP practice where they can, or they have the luxury to have specialists that might be trademark only or copyright only or internet and domain electronic commerce issues only. So it helps to be able to field any and all questions, at least if it's at least superficially, and then to farm out or dig for the right answers. You often learn the technology to the degree you need to in the process of the case. Same with patent prosecution or preparing patents or litigating patents. You bone up on the technology and become an expert to the degree you need to for the purposes of the litigation. So litigation provides possibly an opportunity to be heavily involved in the IP area without the hard IP background.
So you mentioned professional development. If I wanted to diversify my practice at some point in time, would you deem it as appropriate or acceptable if I decided to go to a community college and pick up an associate's degree and one of the hard science background to pursue patent prosecution?
Post law school, when I had already been employed as an IP attorney, my first couple of years, took additional classes at Indiana University, IUPUI through Purdue, to deepen my background in electrical and metallurgical technology. And I haven't checked the current rules, but back in my day, when you sat for the patent bar, if you check those enrollment requirements, there are certain technical hours you have to meet, X hours, for example, in a hard science. But also there's a factor that is called the kind of apprenticeship or practice hours. If you are employed and work in the IP area under the supervision of, say, a registered patent attorney, and you're doing kind of patent prosecution work, sometimes those practical hours can equate into class hours for purposes of sitting and trying to meet the minimum requirements to sit for the patent bar. And I never discourage people from furthering and deepening their education, particularly in the IP area where technology, when you look back when I broke in to today, it's the Model A car versus the Ferrari. So I am constantly relearning technology, and now digital technology, wireless technology, Bluetooth technology, things that I've never even heard of back in the day when I broke into the field. So it's always an ongoing process of furthering your education. So doing something like that to really better prepare you for the patent area particularly is a good idea, and I think well worth the investment.
I know you said that you started at a boutique firm.
Yes.
Is that something that you're finding law firms are doing as far as compensating for that continuing education?
I was not compensated for it. I mean, I got paid for my job, but that extra additional training was out of my own pocket because, again, I just saw it as an investment in my future and almost a no-brainer. I mean, if you want to get in that area, there's just certain things you have to do, and cost kind of becomes a secondary factor, in my opinion. But there are also a lot of bar association and professional trade association training opportunities in the patent area, what we often call patent prosecution boot camp, where you go for a week or two, 8 hours a day, assignments at night, where you learn how to prosecute patents, how to prepare them, learn the PTO rules, the Fed regulations, and the statute. And you're meeting with national experts who literally, you have to do homework, come in the next day, they review, you discuss, you edit your work, and really helps people accelerate their skill set.
What qualities do you look for in incoming attorneys, whether it be from a summer associate, a lateral attorney, or somebody coming in fresh out of law school?
One is kind of a self-reliance and be very resourceful. If you have issues and questions, investigate them to the best of your ability yourself answer the questions the best you can yourself before you go. And I say this not in a derogatory way, but to interrupt the partner, for example, with what turned out to be a very simple question, and had you just pulled the reg and looked at it, it was clearly stated there, or you looked in the statute. That's what bugs attorneys when someone's bugging them with simple questions. As a lawyer, your job is to learn the law and know the law and find the law. So taking a shortcut by trying to just come back to the partner who assigned you the project, or anybody for that matter, that becomes a kind of a pet peeve to many attorneys in my experience. An ability for client development is critical. And in most, again, private law firms, the reality is you have to have that to build some of your own business, your own book of business, if you will, to ascend to partnership. It's difficult to do it without some of your own client development. And it's not, I don't mean to sound so cold that you have to bring in X dollars and be able to bring all this to the table before you're considered a partner. It's not that cut and dry. But the more you're able to develop your own clients and develop your own book of business, the much more attractive you are for a private law firm, and I think that much brighter future you have.
Thank you so much.
You're welcome. Thanks.